Do you know what makes a marriage valid? Who can be parties to a marriage? Can a marriage be declared void or voidable? Who may solemnize marriage? Let me discuss it with you in this video. There are essential and formal requisites for a valid marriage. The essential requisites are the legal capacity of the contracting parties, who must be a male and a female, and consent freely given in the presence of the solemnizing officer. On the other hand, the formal requisites of marriage are authority of the solemnizing officer, a valid marriage license except in the cases provided for under the Family Code, and lastly, a marriage ceremony which takes place with the appearance of the contracting parties before the solemnizing officer and their personal declaration that they take each other as husband and wife in the presence of not less than 2 witnesses of legal age. The absence of any of the essential or formal requisites shall render the marriage void ab initio, except those solemnized by any person not legally authorized to perform marriages where either or both parties believed in good faith that the solemnizing officer had the legal authority to do so. A defect in any of the essential requisites shall render the marriage voidable, while an irregularity in the formal requisites shall not affect the validity of the marriage, but the party or parties responsible for the irregularity shall be civilly, criminally and administratively liable. Any male or female of the age of 18 years or upwards not under any of the impediments mentioned in Articles 37 and 38, may contract marriage. There is no prescribed form or religious rite for the solemnization of the marriage is required, but the parties are required to appear personally before the solemnizing officer and declare in the presence of not less than 2 witnesses of legal age that they take each other as husband and wife. Marriage may be solemnized by any incumbent member of the judiciary, which includes judges and justices, any priest, rabbi, imam, or minister of any church or religious sect duly authorized by his church or religious sect, any ship captain or airplane chief in cases of marriage in articulo mortis, any military commander of a unit in the absence of chaplain assigned, during military operation and in cases of marriage in articulo mortis, and any consul general, consul or vice-consul in the cases of marriages between Filipino citizens abroad. The following are void marriages: those contracted by any party below 18 years of age even with the consent of parents or guardians, those solemnized by any person not legally authorized to perform marriages unless such marriages were contracted with either or both parties believing in good faith that the solemnizing officer had the legal authority to do so, those solemnized without license, with exception, those bigamous or polygamous marriages, those contracted through mistake of one contracting party as to the identity of the other, those subsequent marriages that are void under Article 53 of the Family Code, those where either or both parties are psychologically incapacitated. Lastly, incestuous marriage. Thank you for watching The Legal Doodler. Be sure to like and share this video and subscribe to our channel for more legal videos. You may also follow our Facebook, Instagram and TikTok page.